Act 1, February 2013, the petition that asked the right question just too early. In 2013, a mysterious, ghost-written petition landed at the steps of the Supreme Court. It posed a deceptively simple question. Is sports performance an excluded commodity under the Commodity Exchange Act? The petition pointed to the definitional fog surrounding various gambling laws, PASPA, the Wire Act, UIGA, Dodd-Frank, and coined a fitting term for it, statutory ping-pong. Unable to define better wager, these statutes play statutory ping-pong by deferring to each other. But this wasn't just a semantics exercise. The petition also made a prediction, one that would turn out to be remarkably prescient. Absent immediate clarification by this court, our nation will enter into another period where the courts are clogged with decisions that are inconsistent and conflicting with each other. The petition was attached to an obscure bankruptcy case. No headlines, no noise, just a question that was ahead of its time. The Supreme Court declined to hear it. Unsurprising? Sure, but unfortunate, because it was the right question. Just a little too early. Act 2, October 2016. The master question returns. In 2016, another petition landed before the Supreme Court, this time tied to the potential repeal of PASPA. It was framed slightly differently than our 2013 submission, but at its core, the same showdown, federal versus state control over sports contracts. And this wasn't New Jersey's first trip up the court steps. It was round 2 in the Garden State's campaign for judicial clarity. This time, the Supreme Court said yes, they took the case. Once again, we had a lot to say. We submitted an amicus brief, ghost-written just like before, but reviewed and refined by Fisher Broyles. We argued that sports bets are unregulated commodity futures contracts squarely within the CFTC's jurisdiction. One former assistant U.S. attorney who read the brief had this to say: "Novel and clever. Well done. I fear the court may not grasp what you're saying, but it won't be because it's not well said. We appreciate the compliment. And frankly, we believe the justices would have understood had they truly engaged with the argument. No doubt, they're all brilliant minds. But sometimes even brilliant minds choose not to go there." Act 3, March 2021. The universe answers. Back in 2013, when we asked the deceptively simple question, is sports performance an excluded commodity under the Commodity Exchange Act? The answer disappeared into the regulatory void, lost in space, floating through the ether. But then, the universe decided to speak. And the voice it chose, none other than CFTC Commissioner soon-to-be Chairman Brian Quintenz. The turning point came when a designated contract market, Eris Exchange, decided to test the limits. In December 2020, they self-certified a set of NFL futures contracts. Sports bets. 9 days later, the CFTC stepped in and initiated a review. But before that process could play out, Eris saw the writing on the wall and quietly withdrew the contracts. Still, Commissioner Quintenz wasn't about to let the moment pass without comment. He issued a public statement. His statement was noteworthy for 2 reasons. First, he answered the very question we posed 8 years earlier, affirming that a football game is a commodity. And second, he made a prediction of his own. But the legal analysis and interpretations will remain secret until forced into the open by another, bolder exchange's decision to see a self-certification process through to a conclusion. And as it turns out, just like our prediction, his would prove prescient. Act 4, June 2025. The predictions come true. In 2013, we made a prediction. In 2021, Commissioner Quintenz made his. Let's see how they played out, shall we? Enter Kalshi, another designated contract market. In January 2025, Kalshi self-certified a sports contract, and this time, the CFTC did nothing. Crickets. The states weren't thrilled. Cease and desist letters started flying. Kalshi answered back, filing lawsuits in federal court. Nevada was first. Kalshi secured a preliminary injunction. Then came New Jersey. Kalshi won again. Maryland? Ongoing. At least 4 other states have sent cease and desist letters, some of which are almost certainly headed for litigation. Just 2 weeks ago, 5 new cases were filed in state courts in Kentucky, Illinois, Massachusetts, Ohio, and South Carolina. Exactly as we predicted. 12 years ago, the courts are getting clogged. A foreseeable mess, now in full swing. And just as Quintenz predicted, in 2021, a bold, no, audacious exchange stepped up and pushed a self-certification all the way through. The furthest along case is in New Jersey, now appealed to the 3rd Circuit. On June 10th, the state filed its brief, arguing that the Commodity Exchange Act does not preempt New Jersey's gambling laws. But let's be honest, this isn't just about preemption. States feel threatened. A federally regulated exchange walking into the sandbox? That's a business threat. A chorus of states and tribal interests echoed those concerns in their supporting Amicus briefs, each trying to protect their own turf. We get it. Sympathy may be warranted, but sympathy cannot trump statute. We are New Finance Institute now. Once again, we decided to weigh in. We submitted an amicus brief in support of neither party, urging reversal. New Jersey claims that the state's gambling laws are not preempted. We disagree. But we also don't believe Kalshi should be allowed to launch a national sports gambling operation simply because the CFTC failed to act. Read our full brief at newfinanceinstitute.com.